All right, terrific. So I think we're running a few minutes over, but luckily you'll notice that in the schedule we've sort of built half-hour sort of bridge times essentially between each session. So I think we should be all right. So I think Monica will introduce the panel, but I think this one will run from now until maybe about a quarter till, at which point we'll take about a 15-minute break. So yeah, Monica, I guess I'll let you take it away.
Awesome. Thank you very much. I am so, even though I'm a banana slug and a Cal grad, I am so happy to be here. It is just such an absolute delight, and I want to thank the organizers. If you didn't see it, can everybody hear me? I want to make sure we don't have any miking issues here. Raise your hand if you need it louder. Okay. IB people? We'll give them a chance. I'll speak louder until they adjust the mics, but wave or make noise if you can't hear, because that can be very frustrating. This is an incredible panel. The whole experience of being here back in a law school makes me feel very old. And I turned 65 this month, which totally is traumatizing me. I cannot believe that I'm turning 65. I'm going to be qualified to get my MTA card for half price on the subways in New York, where I live now. And it's just incredibly nerving. But to prove to you that I'm truly a baby boomer, I've been with ALM for 29 years, 13 years here in San Francisco. I was raised here, and I'm a graduate of USF Law School. Lawyer, I practiced law for 5 minutes, and then went back to journalism, literally. To put this in perspective, when I wrote my first story for the Recorder, I did it on an IBM Selectric typewriter. I used an IBM Selectric typewriter to take the bar exam. When I had DOS on one of my first computers, I was one of the first people at the Recorder to have what we affectionately called a Trash 80, which was a Radio Shack thing this big with these big clunky acoustical couplers that you would put on both ends of the telephone. And from the Hawaii American Bar Association meeting, I filed for the first time my story electronically. Windows 95, I was the first person at ALM to get Windows 95. I am not under the hood. Thank God Sean Doherty, my technology editor, is. We are as opposite as you could possibly be. He's methodological. He could be. He never gets upset. He's very orderly. He's under the hood. He's a total geek. He has dual degrees from Berkeley, from Boalt Hall, and from their research. And I don't know the exact acronym for it, but he is the librarian in research things, and he could be a CIO anywhere. I'm like a seventh-year associate at Big Law who knows she's going to be partner and refuses and won't learn anything, hates training, won't read manuals, wants the latest technology, but doesn't want to have anybody spend more. I just want it to be completely intuitive. Surprise, surprise, I become an Apple girl. What a shocking surprise. All that being said, and one other thing to prove to you that I'm a geezer, is the first airline flight I took was on with my father flying for United Airlines, a DC, I'm blanking on the actual one here, DC-4B to Chicago for 7 hours. So I love my job because I have the attention span of a gnat. And I have never been bored. I'm the poster child for ADD. And the great thing about technology is when I was called to New York to take over Law Technology News, I haven't been bored for 1 minute because it changes so fast and it's so interesting. So just bear that in mind. The reason I share this confession with you is that if I ask a really stupid question of this wonderful panel, would you please remember that I'm like the non-geek in the room? So be kind to me if I ask a stupid question. I've found in life that stupid questions are usually very good. So what I'm going to do, now that I've confessed all my flaws to you, is to introduce you to this fabulous panel. We have Brian Carver from the Free Law Project, Thomas Bruce from the Legal Information Institute, Paul Sawaya, I hope I got that right. No. Tell me because I want it right.
It's pronounced Sawaya.
Sawaya,
Yeah.
sorry. And I'm going to let you say the name, Restatement, correct? And Julio Avalos, did I get that correct?
No, but it's all right. Keep it going.
Fire me already. Tell me how to pronounce
Avalos.
it. Avalos, yeah. Sorry about that, from GitHub. And I'm going to have each one of them, now that I've botched half of the panel's names, tell you a little bit about who they are, what they are, and then we're going to dive into a very, very, very interesting conversation on the access of information. Why don't you go first, Julio?
Sure. My name is Julio Avalos. I am the General Counsel and Chief Legal Officer at GitHub. It's always hard to judge at these conferences whether you're talking to a room full of lawyers that are interested in technology or technologists that are interested in law. So I'm not sure. For those of you that haven't heard of GitHub, GitHub is a platform for collaborative social coding for software development. It's the largest repository or really source or resource for open source software. And I'm excited to be here. I left last year's FutureLaw Conference excited. It really inspired a lot of my work for the rest of the second half of 2013. And I hope that at the end of today that you all, and those of you who are joining remotely or who watch this recorded, leave with ideas that impact your own practice and that start at the very least conversations with your colleagues and your coworkers in whatever space you happen to be. Because I think that part of the benefit, to Professor Susskind's point, of meeting and having these conversations like this are to have the conversations. Otherwise, we should just be talking online, right? So hoping to meet a lot of you and to hear about interesting stuff that folks are working on. The development of an open legal data ecosystem, for me, is a critical component to our industry's ability to meet the needs of our clients, to meet our own needs, and to meet the needs of an orderly civil society. So I'm excited about talking about that. I think Professor Susskind touched on a lot of what at least my interests in the space are. If you don't know of him or his work or weren't able to hear what he said, I think the audio, it was an unfortunate situation because he has a lot to say. And really we're trying to put flesh, I think, on bones that the professor has been working on really for decades and has pioneered. There's an old Sufi joke, although it's called the streetlight effect. You see it in a lot of different cultures where it's some apocryphal parable of a man who's lost something and is looking for it under a street lamp. Sometimes it's a drunk, depending on the way that the story goes. And he's looking for something on the ground, and a policeman walks by and says, you know, what are you looking for? I'm looking for my keys. I'm looking for whatever it is that he happens to be looking for. And slowly but surely people walk by and see now two individuals that are looking for something under this street lamp. And okay, yeah, I'll help. And slowly but surely people start helping out. And then, you know, they've been looking for a while. They're not finding it. It's not a large area that they're looking under. It's well lit. And they ask the drunk or the person that's lost his keys, you know, where exactly did you lose your keys? And he points off in the distance and he says, you know, all the way over there. And then he's asked, well, why are we looking under the street lamp? And he's like, well, there's no light over there. And I think that largely plays true and holds true for lawyers in the legal industry. To Professor Susskind's point, there is a general sense, and I think an increasing sense in the last 3 to 5 years, that things really are broken, that we've lost control or are failing to engage with developing technologies, except to the extent that we inherit the problems and the increasingly staggering volumes of data, of precedent, of communication, of work that's out there. We've taken all the bad, but really failed to understand the technologies that we're using that have given us these new problems and these new issues, and that we're continuing to look for issues under the light of the street lamp. But in reality, a lot of the solutions that are out there already exist, but they just happen to be either in the dark or around the corner or somewhere that we can't see. And I'm excited to be on the panel with other folks who are working on this and who have pioneered or are working in the dark, I think, and trying to get lawyers to build a street lamp over that area, right? So I'm excited, and there's plenty to talk about, but I think I'll cede to the rest of the panel.
Paul.
Hi, I'm Paul. I'm a computer programmer, open source. Oh, sorry.
No, pull your mic closer to you.
Pull it closer. Okay. Is that good?
Can you hear?
Okay. I'm an open source software developer. I spent some time working for Mozilla and on different web projects. And I came to FutureLaw last year out of just a slight interest in learning about a new domain to work in. And I really like some of the kind of attitude and atmosphere here, and I liked it so much that I started working on a project of my own. I think what Julio said about right now everyone looking where the light is as opposed to where the keys are is an interesting metaphor. To me, it reminds me a bit of what I've read of the Homebrew Computer Club back in, I think, the 70s, where the original Apple founders demoed the first Apple I. I think everyone here is kind of working on their own projects, and everyone kind of has this idea, this vague general direction of where things are heading. But there are different ways of getting there, and everyone is kind of trying their own way. And my guess is that a lot of the projects that are going to really succeed are being built by people in this room. So I think it's a really exciting room to be in, and I'm really excited to hang out and chat with all of you after this. My own stab at computerizing law it's actually this project is a very small, like very cleanly scoped project. It's basically an attempt at building a really simple format for legal documents, and it starts out as something that's in a traditional kind of format that's used by word processors already, something that might be in a Word document, and allows a human to parse it and put it into something that's structural and more semantic and can be easily displayed on the web or manipulated by code, and that's it. I think that's important for the legal technology community to have, because I think in a lot of ways legal text is missing its HTML. It's missing something that's easily machine readable and machine manipulatable. So my hope is to try and build some of that and see what other people can build on top of it. I think it's really exciting to imagine what can be done when someone hacking over a weekend can generate a complete incorporation for a company or a will or some other legal process by running a Python script on their computer. And I think that we're pretty close to getting a good open source technology stack that allows that to happen. So my hope is to build some of the underlying technology for that.
Thomas.
I'm Tom Bruce. I was first identified as a purveyor of disruptive technology in elementary school in an incident involving a soda straw and a gelatin cube. In 1992, along with Peter Martin, I started the Legal Information Institute at Cornell, which I suspect many of you know. In 93-94, I was the author of the first web browser for Microsoft Windows. In the intervening however many years it is that I hate to think about, we have grown to certainly the most trafficked, although by no means the most comprehensive open access legal website in the world. We serve about 25 million unique visitors a year from something like 207 countries and territories, and we account for about 2/3 of Cornell's web traffic, which is nice when the dean has discussions with the provost. My own interests these days are turning increasingly towards semantic web representation, not of case law, but primarily of regulations. I sort of think that in law school, certainly, and to some degree in legal informatics, we have given a lot of primacy to case law, partly because of the biases of lawyers, and particularly the biases of legal academics who are somewhat preoccupied with edge cases. And in fact, regulations are the largest contact surface that much of the public has with the legal system, and that's where I'm putting my attention these days.
And Brian.
Okay, my name is Brian Carver. I'm an assistant professor at the UC Berkeley School of Information. I'm also an attorney. I went to that other law school in Berkeley. And I want to talk to you today about Free Law Project, a nonprofit that my colleague Michael Lissner and I started last fall. And one of its chief objectives is to make the entirety of United States case law available to the public online for free. And I think we should find it absurd that this hasn't already been accomplished. In 2014, you mean I can't get all of U.S. case law online? This should be a done project. But in January, I came, I think even to this room, to Stanford at least, and spoke with the title, "It is long past time for free online access to the law." And the video of that talk's available from CodeX, and we link to it from freelawproject.org. And so that talk lays out my argument for why the entirety of U.S. case law should be available freely online. And so if you're not already persuaded that this is a good idea, you can watch that talk. But I'll focus today on how achieving that goal and how pursuing some of Free Law Project's other objectives would help to forge an open legal document ecosystem, the topic of this panel. But I think it would be helpful to give a little introduction of how we got to where we are now. In late 2009, well, and even earlier than that, I had a problem. As an academic, I like to stay on top of new developments in the law. My particular area of focus is copyright and internet law. And so, for instance, if a new copyright case comes out of the Sixth Circuit, I want to know about it that day. I want to know about it right away. I don't want to, 2 weeks later, read about that case on some law blog. I want to be the guy writing that law blog, right? And I've used many daily alert tools, and when I was at a law firm, I had access to some expensive daily alert tools, and I found them utterly inadequate. They were over-inclusive, they were under-inclusive, they weren't timely, they were expensive. And so I laid out this problem to a student at the time, Michael Listener, he's here, the tall guy in the back, and said, please help me with this problem. Most of the appellate federal courts put their opinions online. We just need to scrape all the circuit level courts and the Supreme Court, put them in a database, make it searchable, have it send me an email every afternoon with my areas of interest, my queries. Amazingly, he did this all by himself in the 3 or 4 months that we allow our master's students to work on their final projects. And by May of 2010, when he put courtlistener.com online, I think it was the best daily alert tool available, and maybe still is, because it was not over or under inclusive. You could write up your query to get you exactly those documents that you cared about using advanced Boolean search terminology and so on. And it was very timely. I got my email every afternoon at 5:30, and it was free. Right? The problem, I guess, was we knew that people would come to the site and probably want to use it as a general purpose legal research tool. There was a search bar, after all, and some documents sitting there. But we had just started scraping the web in 2010, and so we only had documents from 2010 forward. And that's a horrible data set from which to do general purpose legal research, right? We needed the back catalog. We need all the old cases if people are going to actually use the site for that purpose. And so Michael had to graduate and get a real job at a legal search company nearby. But he remained interested in the project, and he and I have worked together over the last 4 years to fix this problem, to start filling in the back catalog. And actually, I would characterize the objectives as falling into 3 buckets. The first is what I just talked about, getting the documents, right? The second thing that we've been trying to do is build legal research tools. I don't want the public merely to have access, full stop, to the documents. I don't think they should have to settle for a second-rate search engine to access the tools. They ought to have cutting-edge technology available to them as well. So we also want to build all the great tools that you expect when you're conducting legal research. But then third, we want to support academic research. Okay, I can say a little bit briefly, because I know I'm already
That's all right.
past my time probably, about how we address each of those 3 things. So getting the documents, that first objective, has 2 main parts. There's the daily problem. I need to keep up with what all the courts are doing every single day. And over time, we've expanded from just covering the federal appellate courts to now we're almost done with the courts of last resort of each state. There's still a few states that have really frustrating websites that we're working on. But we should finish that very soon. And so then the daily problem is actually maybe one of the easier ones to solve, just getting all the new stuff each day as it comes out. The harder part of getting all the documents is that back catalog. But right now we have 2.5 million court opinions on our site, and it's a good start. We have, for instance, we think nearly the entire Supreme Court corpus going back to the one US one. And so at least for that purpose, it's fairly complete. And there's coverage pages showing you exactly what we have and don't. So you can see whether, you know, if you're doing research in Louisiana, whether we're going to be useful to you or not. So on the legal research tools front, 2 other students who came along after Mike worked with him to create a citator. And so that hyperlinked all of our documents to one another, enables us to now automatically generate a table of authorities for each document and things like this. I've worked with a computer science PhD student at UC Santa Cruz who built this remarkable, what I call legal research assistant. It's not live on our site yet. Mike's going to have to tinker with it a bit to get it ready for prime time. It was good enough for her dissertation. She now has graduated. But it's remarkable the way it sort of takes advantage of some, you know, even well-known technologies that are out there now. Like Amazon can recommend to you that you might also like this book if you like this one. And so we integrated things like that into the search results and got really remarkable results. But then maybe most importantly, last fall we released what we believe is the first ever application programming interface, or API, for United States case law. And so now it's a way, and if we need to explain, an API is a way for computers to talk to computers. And so now other websites that are in the business of putting legal documents online can get access to our entire corpus of documents and integrate them into their site. So for instance, the Sunlight Foundation previously had an alert tool called Scout that would alert you to things like changes in regulations and changes in other parts of the federal government, but they never covered court opinions until we released our API. They said, oh, cool, now we can do alerts for court opinions as well, and so that's already on their site. Or the state decoded folks have done things like VA decoded for Virginia's state statutes, and they make really nice versions of the state statutes, and when we released our API, they were like, it's nice to be able to read the statute, but it's even nicer to have over in the sidebar some court opinions interpreting that statute just one click away. And so they were able to pull in from our site the court opinions that interpret the statute that you're looking at. And so by opening up our documents to everybody else to use, we're helping, you know, the state decoded folks, for instance, make their tool a little bit more useful. And I could, obviously, you can tell, go on and on in this topic. But on the supporting academic research front, we get contacted constantly by people who are blown away even by the paltry amount of stuff that we can give them at this point. So folks from USC, computer scientists who had previously done work on citation networks within scholarly journal articles, got in touch with us and said, we just downloaded all your documents, and you include the citation network in the download, and we're so jazzed to work on this because, you know, scholarly journals, that was interesting. They cite one another, and you can learn some interesting things. But legal documents have really interesting citations. You guys express sentiment about the thing you're citing. You disagree with or follow the things that you're citing, and now we can, you know, start trying to track all that. And they were like, we couldn't find this data anywhere else. They're just gushing, you know, and we're like, yes, that's what we intended. Glad you like it, you know, right?
Okay, I'm going to cut you off for a minute.
Sure.
Okay, because I forgot something extremely important at the beginning of this program. Number one, this is interactive, so please wave your hands and participate and ask questions. Don't feel that we're just a bunch of talking heads. Secondly, not quite yet. Not quite yet. I'll get to you. Secondly, I always like to do a little old-fashioned social media. So would you kindly take one moment and turn to the person next to you or behind you or in front of you, and if you don't know them already, take a very quick moment to introduce yourself. You can exchange cards at the break.
I'm just filibustering, sorry. I actually was given the impression that we were going to do like 10
Okay.
and then converse.
A little disruption there. 10, 9, 8, 7, 6, 5, 4, 2, 3, 2, 1, stop. Thank you. Okay. Stop. It was dangerous, disruptive. Point taken. Okay. Stop. I'll never do this in the middle of a thing again. Okay. I unleashed a monster. Thank you. Okay. So, finish that in the breaks. Thank you, and I apologize for not doing it first. So I have a lot of cranky questions on this thing. This is all really great, but a couple of things I want to throw on the table, and we'll fight over who gets to talk about it is, in my experience covering California for 13 years for LTN, I got the distinct impression that the California courts, even before Keller and the whole world exploded, are completely clueless on how they do their public records. They don't have the staff. Some of them are required to use amazingly WordPerfect. There really are people still using WordPerfect. One of the things that we discovered on the East Coast after Sandy Hook was that we have a wonderful article by Barclay Blair talking about public information in the past. Again, my age is showing. We used to go look at microfiches to look things up. And Thomson Reuters tried to do a big thing to get all the court stuff in California. I'm just blaming California because I know this particular market. Tried to do, they would all say, oh, we're going to do this, we're going to get all the files and everything. It bombed. I think LexisNexis tried to do it. It bombed. And if those money machines can't do it, how do you all think you can get, and let's limit it for the moment to court documents, how do you get this stuff if as a general rule, the courts themselves don't have the resources to maintain it, they don't have the bodies. So how do you pull this off? Who wants to start? Go for it.
Sure. Well, actually, I'm going to disagree violently and say that at this point, I think the trend very much is that self-publication on the part of law creators of whatever kind, if it has not already become the norm at the highest levels, very soon will, and that we're in a classic case of Gibson's quote about the future being unevenly distributed. It doesn't reach down into the lower courts. In some ways, the recession helped us. So, for example, not long thereafter, Arkansas started putting out all of their state decisions as the official reporter, as a self-published document, because it was far cheaper than dealing with the commercial publishers. Mm-hmm. I think the fact that the commercial publishers are, by and large, retreating from primary materials at this point is something of an indicator that the war is over, and that to some extent we won.
Don't the Thomson Reuters and LexisNexis and the folks like that, I've been to millions of meetings with them, and they always argue it that we are offering, and there's a buzzword for it I'm forgetting, value plus. You're going to pick or get both because they're giving you their keynote system. They're giving you Shepard's. They're giving you the ability. You're paying those huge, big bucks. And I think they're in, for both of them, are really in for trouble because there's so much friction from big law, even big law having to pay the kind of bucks they have to pay. But they're providing you the bonus plus. They get them up within an hour. They've got acres of attorneys who spend their entire careers beautifully writing these terse little things.
And that's fine for those who can pay for it.
Exactly,
But
exactly
but
my
I think
point.
the thing that I think the thing that you need to keep in mind is that even West, since the late 19th century, has been selling legal research services as a form of insurance for attorneys.
Good point.
And the thing about insurance is that people only insure to the value of the goods. You're not going to see somebody doing $10,000 worth of online research on a $500 case.
Exactly.
And there's an extensive market that wants open access. I mean, we're seeing it now in parallel with other trends that I'm sure many people in this room can identify far better than I in the structure of the profession itself. And it's not unusual for us to get mail from some guy who was formerly at the practice group leader level or assistant practice group leader level in a firm, who's taken 3 of his friends and said, you know, screw big law, I've had enough of this post-2008. I'm going to go do a boutique firm doing some narrow little thing, and thank God Cornell's there with federal statutes or whoever, because, you know, that's what fits my budget now.
Yeah.
And I think as we see practice, you know, kind of atomizing in that way, these guys are going to paint themselves into a corner.
And what's the outfit that's on the tip of my tongue? That case. There's a small.
Fast Case. You're thinking.
Yes, Fast Case has come up with alternatives. So the price thing and the TR and the LN, you know, value added stuff. That's probably driving a lot of the concern to get but how do you, and Brian and I had an off-channel conversation about this. No matter what it is, somebody's got to write a check for it somehow, some way, whether it's the academic. How do you get to open? How do you do it with somebody's got to write a check for it? You know, and again, I keep going back to the California courts because my understanding of them was it's just this mess that nobody's been able to really do. Somebody has to pay. How do you answer that?
It's a lot easier than you think if people would just do the right thing, including the courts, because computers are these amazing things that, you know, once something's digital, they can make copies and copies and copies at virtually no cost. You know, the cost to run the computer is all you really need in some instances. For instance, we scrape PDF off of most court websites, and that's at least cross-platform. You can read it on your Mac, you can read it on Windows, you know, and so that's, I suppose, why we've fallen into that. But it's not the greatest format for machines to read. And it's not that I even need the courts to become XML experts or something like that. Hell, if they would contact me, I'd volunteer to write something for them that would convert the Word document that the judge and or his or her clerks started with into a nice machine-readable format that all the rest of us publishers would ingest and be thrilled with, right? And that little connection script is trivial to write. You know, going from .doc to XML is a 1999 problem, right? You know, this is solved, right? You know, and so I don't need any court to become a full-service legal research, you know, enterprise. They've got the documents and they need to give them to me, right? You know, is all it amounts to. It's much less expensive than people imagine.
If you're asking too, Monica, where does the money come from in general? I mean, people in my neck of the woods around the world have been trying to solve the sustainability issue in different ways, in different venues for about a zillion years, and there have been remarkably few fully satisfactory solutions. Probably the best one right now is the Canadians, who are financing an open access, fully comprehensive national legal information service on a $30 a year head tax on the entire Canadian bar, which, given that even for smalls and solos in Canada, the average legal research budget annually is on the order of $3,000 to $5,000, is an absolute bargain as far as these guys are concerned. And I suppose there are some who would object that the public are free riding on this in some way, but that's just crazy. You know, so it's doable if you can put together that kind of business model. We've used a combination of selling consulting services and site monetization and public philanthropy to do what we're doing. You can find any model you want to. Out there. It's less clear how this ought to work if you're looking at judicial opinions than it is if you're looking at stuff like stats and recs. Because there, the business value of that information, just in its raw, unannotated form, is so clear that it's a very clear case of trading off present cost of publishing stuff versus future benefits to the public. And if you want to look at an extreme example of something like that, you could look at Jersey or the Seychelles or any of the offshoring centers where there are clear cases. You know, if you let people know what your financial rules are, they will come play with you. And increasingly in the developing world, that's a big concern. They're doing open access to this stuff because they want people to know that they have rules. They want people to know that they have the capacity to enforce them. You know, if I wanted to do a fully sustainable legal information service today in sub-Saharan Africa, I would publish mining law in Chinese.
So is the answer that it's ultimately not a centralized service for the entire United States? It just becomes a lot of little separate fiefdoms and people have to find them?
Well, I wouldn't put it in that way, but I think that the issue that you're raising about who pays for this is largely a question that the open source community had to deal with, you know, in the early 1980s, the mid-1980s, and into the 1990s when it really started coming into its own with Linux as a sophisticated potential business model. And maybe that's a good segue into kind of backing up for the larger audience and talking about what we mean when we say an open legal model, an open legal data environment, an open legal document ecosystem. What do we mean by open? And I think that within the technology space, we take it for granted that folks know what we mean. So when we talk about free or open source in a software development context, essentially what we're talking about is from the free software movement, going back to Richard Stallman, RMS, and all that kind of hacker legendary stuff that he had going on, or that he has going on, is that by sharing source and by distributing and collaborating on a software project, that you can largely get around this issue of, well, shit, I don't have a lot of money. Well, you do have access to a community of folks that are willing to perform work for free or for pennies on the dollar of what it would cost you to go out and get that done in a private law firm environment. So when we talk about, you can imagine that I'm a hacker working in my basement. I don't have the resources to completely debug or vet a particular project that I'm working on. What do? I can put it up online and someone can see it in the community. I can crowdsource the development of that software, and that in that way you're having the higher levels of efficiency, higher levels of reliability. The software operates better is the way that the theory goes, because you're essentially rebuilding a peer review model where you're opening up your code to scrutiny, and that the work product at the end of the day is going to be better because of it. In a legal context and as an in-house counsel, this is attractive to me because you can imagine a world in which my own governance documents, or the legal documents that I use internally on a regular basis, that are woefully out of date because I'm 3 weeks away from that blog post that is going to tell me about that Northern District of California opinion that's directly relevant to legal exposure that I have within the company, that I'm 2 months away from a client alert from a law firm that's going to randomly make its way into my inbox and tell me that, oh, you know, the Supreme Court ruled on this thing 3 months ago. Pay attention, give us a call, and we will bill you for it, right, to make the changes that you need to make. But you can imagine a world in which someone with quick and easy access to the opinions that I don't have could go on GitHub and, instead of emailing me a client alert, actually create a pull request, create a patch for this all of a sudden out of date, out of compliance, illegal, risky line that I have in my terms of service or my employment offer letter, my termination document. All of a sudden that's become out of date. So how do I get access to that information? Well, I could pay for it. I could pay a law firm to do it. And they're going to do a bad job of it. And I'm going to have to redo it and retranslate that document into something that isn't going to get me fired. Or I can go kind of this open source model where I could have my offer letters up on GitHub or up on the net. And that then someone in Milwaukee, someone that doesn't live in the Bay Area, someone that didn't go to the fancy schools that you need to in order to get in front of me, because I don't, right? How do you get work in front of clients in Silicon Valley if you're not at one of the fancy shishi law firms? You don't have a way to do it. You can either move to the Bay Area and try and get a gig, you can kind of try and blog about it, or it would be much simpler if all of a sudden I get a random pull request from a lawyer that has an interest in this, that I can look at it, I can vet it, I can go back and I can read the case. I can then go to the law firm and say, hey, what do you think about this? And then all I have to do is press a button and merge it and have a sustainable, cheap way of keeping up to date with my legal documents. And I think that this linchpin, I think that the open source, again to Professor Susskind's point, that it's going to be up to general counsels, it's going to be up to in-house legal departments to really make this work, because we're the enablers for big law. We've been unable to wean ourselves off of big law and the big law model, and the truth is that they don't know any alternative to it. So I do think that there's a power that in-house counsel have to get law firms to change and adjust their behavior and to adopt new technologies that lower prices and that provide a better service and a better product, that we're going to have to take on that responsibility to educate folks, because we have flexibility, we have visibility into new technologies, and we have the ability to take our business elsewhere and vote with our feet. So if folks aren't able to provide that sort of service, that then we can go and simply use someone else. And I think that for me is really kind of the power of an open legal data model, which is lowering barriers to entry for attorneys to get into spaces that they otherwise wouldn't be able to get without spending a lot in overhead and fancy legal degrees from fancy law schools, where really all I want is the right answer, and I want you to be thinking about deep thoughts about what I don't already know. Like, I'll already stipulate to the fact that if you're a lawyer in the Valley, if you're at a fancy law firm, you probably know, you can tell me what the law is on this, you can tell me what the law is on that, but I want higher level thinking, which isn't what we're training lawyers currently to do, and that there is an overlap in the Venn diagrams between the tasks that attorneys at law firms find dehumanizing and soul-crushing, and that can be automated and opened up to technology, so that we're then free to deal with these issues. Susskind's point about, if you look at this list, who isn't so scared of their business being disrupted by this list of 13 new technologies or developments that are happening in the space? It's the lawyers that are going to court. It's the lawyers that are talking to counsel. It's the folks that have good bedside manner. It's the folks that are actually adding value apart from the access to information that they're able to pay for, that I'm not able to pay for, that I don't have time to sift through. So I think that there is something in this open model that solves not only for the high levels of cost and the increasing level of cost that we see in the legal industry, despite the fact that information technologies and other industries, we've seen diminishing levels of cost. Legal keeps rising up and to the right, so why is that? Open can solve for that in some way. I think it also solves for a more fundamental problem that we have in the legal industry, which is a lack of belief, a disaffection, a lack of excitement with respect to what you're doing, and an almost embarrassment when you're telling people, well, what do you do? Yeah, I'm a lawyer. Shit. Well, that sounds...
I'm cut you off because we have a question from the gentleman here.
Yeah.
Will you identify yourself?
Thank you. Larry Bridge-Smith with ERM Legal Solutions, and the dialogue is deeply appreciated. And I want to ask a question relative to whether it has to be either or, and that's the question I think we often find ourselves posing in terms of solutions. Why can't it be a both and? Without diminishing the power of open source. Please don't hear me say that. I want to go back to something Brian talked about, and that is the power of API integration. So I would love that we would all do the right thing, but unfortunately we're all motivated by some level of self-interest, right? So how can we allow a system evolve in which self-interest can be best served by doing the right thing through the power of API integration, so that tools can now be conjoined to solve a bigger problem? And that's what's happening. I think that integration strategy is allowing those who are doing these good things for an economic return to continue to build that infrastructure, that platform that Monica referred to, where these resources can be acquired in great order and at significant magnitude.
Brian?
Yeah. No, I think if an answer to your question is actually also my answer to Monica's question. She asked us, who pays for this open legal ecosystem? And I guess what I would emphasize is that we're already paying through the nose for our closed legal document ecosystem. And here's how, right? If you're a venture capitalist or an angel investor in this room, and I think I saw some, you should be angry that legal technology startups are wasting your money. Now, before all the startup guys run down here and drag me off stage, let me explain, right? They're wasting your money because they have no other option, right? Now, they got into the legal technology startup space because they think they have a better mousetrap, right? They think they do have some value add to the legal documents that's going to make them a going concern, right? They can use our collection of documents to build their prototype, and they can show it to the VCs, and then they can get funded. But just as soon as they want paying customers, our collection of documents, because it's currently incomplete, is just not adequate, right? And so they end up having to pay someone to acquire public domain documents. Then the next startup does the same thing, and they pay for the same public domain documents. And then the next startup does the same thing, and they're paying for these same public domain documents over and over again with the VC money. And the VCs should just write me a check, right? I'm here all day and able to accept them because then I'll put them all online for free for everybody, right? And every one of these startups can start from a level playing field where they all have access to the documents that we need, and then they can compete. It's a start, and I'll take it.
So here's a controversial question for you, and it's particularly ironic since one of the sponsors here is Thomson Reuters. Anybody here from TR? Okay, chime in. Lots, good. So why not go to TR and LN and say, do this? And the TR folks, what are you guys doing? And Tim can give you a mic that addresses these issues. Is there some way, rather than having the big law crowd being up in the sky, and is there a common ground that where there can be more back and forth between these organizations that probably have 95% of the documents you want? Maybe I'm naive, but any TR folks want to talk, or LexisNexis want to address that? I'm not seeing anybody jump up. Oh, there we go. Okay, and hey, identify yourself.
Hey, Monica, it's Chris McGuire.
Hi, Chris.
Hey, how you doing? So I think that one of the interesting things that we are thinking a lot about and is around opening up platforms, and I think the API stuff that Brian talked about is very, very intriguing. I think, you know, we're doing some stuff, cloud-based practice management tools, for example. And I think one of the things that, you know, we think a lot about going forward is, you know, do you open up that platform? And I think you hear Susskind talking about chunking out legal work. He way more articulately describes it than I do, but I think as you chunk out legal work and chunk out process, things are going very practice area specific. So I think there's room, you know, for us as we think going forward, you know, certainly considering, you know, opening up our platforms more to allow, you know, us to collaborate more with startups, particularly as we see so many things, very niche practice area, you know, specific things going forward. So that, you know, certainly something that we think a lot about.
And one of the questions the panelist asked me to ask is, should law firms themselves be moving their documents to the cloud? I mean, there's always a lot of concern about bad hacking and as in confidential client information, not good hacking, bad hacking, and the ability to protect. But does it matter that a lot of law firms of all sizes are starting to move things into the cloud? Are they getting over their fears just like they got over their fears of using cell phones? Looks like you're trying to... Well,
I'm looking for a little better definition of the question. Are you talking about security issues related to private work products sitting out on the cloud, or are you talking about law firms essentially making work product freely available for reuse?
Well, and forgive me for being vague about this, just as when cell phones first came out and people were really nervous and the American Bar Association had to say, yes, it's okay that you can use cell phones, in the past there's been resistance to adopt, in e-discovery, in lots of things, there was a fear of the cloud that it would not be a safe place to put sensitive client, you know, there's an obligation of all lawyers to protect client confidentiality. I just did the current issue cover story is on like cybercrime. So if there were fears about putting anything in the cloud that seem to be being overcome as the cloud becomes more and more secure, and you're seeing small firms going to things like Clio and Rocket Matter and so forth and so on, is that going to help in any way? Is it even a factor if firms themselves are starting to trust the cloud? Will that help the open source crowd at all, or is it just not relevant at all?
See, my experience of it was a little different in the mid-'90s. There were these guys coming up to me in the front of the room and saying, well, how do we know that that version of the Supreme Court decision that you have on that website hasn't been altered by some malicious 13-year-old? And 13-year-olds are really heavily into changing commas and securities regulations. And the same guys who were asking me that, you would then see in the lobby talking on the cell phone to some client about some matter, and it's like, really? Really? So to answer the question you actually asked, I think it's completely orthogonal.
I'm sorry?
I think it's completely orthogonal. I think they can either put their documents in private space or in the cloud or not, and it will make very little difference to what happens to us unless they're publicly publishing them.
Yeah.
Anybody disagree?
No, I agree. I think that it, largely doesn't impact the open source or the development of an open legal ecosystem, except to the extent that it requires lawyers to engage with technology, engage with computers in a different way and in a more sophisticated way. If law schools knew that they needed to train their law students to actually be technically fluent after graduation, and that was going to be a key piece of your own career development and your ability to get a job, that then potentially that could have an impact there. But sure, and Google had that issue for Google for Business. Convincing businesses to put their corporate emails in the cloud seemed like a huge hurdle to get over 4 or 5 years ago, but that largely seems to be something of the past.
I certainly don't think that should stop a law firm from open sourcing their own documents in template form, but I do think that it's important to be careful about the promise of open sourcing things. Like Julio mentioned Richard Stallman, if you read some of RMS's early writings, he suggests that maybe the way to handle the free software ecosystem is to institute a software tax and have everyone, just pay to fund software as a public good. His arguments are mostly moral, not pragmatic, and I think a lot of the stuff that Brian's doing would either have to be funded by a government or a private institution or by a software project that is shared by many private companies. Because the reason the open source software movement has worked so well is because it helps a lot of companies make money by saving costs, by coordinating on individual projects. So
now we just have about 5 minutes, and I'm not. Oh, okay. Can we go a tiny bit longer?
Questions up there.
Okay, up here first. Can you ID yourself, please?
Yeah, I'm Bob Purvey with Google.
Hi, Bob.
We're friends.
We sang in
she lived out here.
choruses together.
I'm not here to speak on behalf of Google. I should preface this with that. So if you're looking for money, don't come to me. But I do have a concrete example of open sourcing. I'd like to strongly echo what Julio said. I think that is the answer for solving some of these problems. And the concrete example is I got this PDF from somebody at the Public Patent Foundation that had all the claim constructions that have been done in patent law. Those of you who don't work in patents, that may not mean much, but if you do, you know how valuable that is. So I wrote a parser, the idea being that you could just hover over that part of the claim and it would tell you what it's been construed to mean. And I don't have permission to offer this, but I would like to work with someone else if you guys want to work with me in putting this in the public domain, making it available to everybody, and especially maintaining it. Then talk to me at the break.
Great. And there was another question over here. Thank you, Bob. Yes. And please ID yourself.
This is a fabulous panel. I'm Tanina Rostein from Georgetown. There's another piece of this that's also very exciting. If you go to the Madison Project, which is coming out of OpenGov Foundation, they've actually they have a platform where you have a proposed bill, And it allows for comments from the public. It allows comments to float up to the surface, and it really allows citizen participation and empowerment. So I wanted to add that to, and this is a spectacular panel. I don't want to detract from it, but wanted to put that in the mix too.
Thank you so much. Okay, 1 minute apiece, because we got to close. Starting with you, Brian. What's the one thing you want to walk away from? 1 minute, Brian. For this audience to know and think about for the next conversation about this?
I guess I managed to say almost everything I wanted to, as you noticed. But if I were to add anything, is that Mike and I do hope that we're the last people who have to work on this problem. And so we've designed our activities to try to ensure that. A lot of people have tried to put all the documents online and have made it so far, and then they run out of money or interest or whatever, and their effort just disappears. I am going to be damned if that happens to me, and here's how, right? All of our code is open source. You can download it and run our site on your own server today. All of our documents are freely downloadable. You can download them all and create an exact replica of our site today. And so if on the way home today, in the awful traffic between here and Berkeley, Mike and I meet our demise, right? I expect one of you to pick it up right where we left off, right? And it'll be possible for you to do that. No one has to ever start over on this project again.
Great. Tom?
Can I have my dollar back? So, without using this as a 1 minute intro to sort of lead to the 10-hour lecture that should really follow it, let me just say this. Monica was subtly hinting a little while ago that part of her reservations about this document ecosystem, or this legal information ecosystem, in which there are many, many, many independently acting self-publishers, commercial publishers. I think, Larry, that the public-private partnership is inevitable given the scale and diversity of the market. You know, to the extent that the semantic web actually represents a series of real technologies that are very capable of things like metadata merger and other kinds of a closer representation of what we have, to the extent that it really is something practical that's about piling up statements about things and being able to merge large data pools together, that and a set of interoperability standards is really the answer to what you're talking about. I mean, that's where we're going next. I don't know that it's going to get a lot of platform time at this meeting today, but it's certainly something I'm happy to talk to anybody about, because I really think that's the next thing.
Thank you. Paul?
I think it would be interesting to start thinking about technological solutions to the problem of data being lost because of companies' flimsy business models or getting acquired or projects losing steam. And this is one area where legal technology could potentially lead ahead of the web, because the web really hasn't solved this problem yet, which is why you have projects like the Internet Archive trying to desperately download everything from a blogging site like Posters when it gets acquired. So maybe some sort of distributed systems work could be done here that actually could be original work that could benefit the rest of technology in general. And I think that's a thought-provoking thing to leave off on.
Thank you. Julio?
I really like the point that was made by the gentleman from Google. I think that anyone that's been involved in litigation or that's worked with a group of other attorneys knows that there are efficiencies that you get from just seeing something. How did you deal with that issue? How did you deal with that problem? And the economies that you get even from a joint defense group and being able to share information are economies that even within law firms are not taken advantage of, and certainly not taken advantages of between law firms or across industries. When you think about the inefficiencies, our practice, the legal practice today, is defined by challenges and crises of repetition, of forgotten arguments, of misplaced folders. Someone saves a contract to the wrong folder, and that literally is going to doom you to recreate that work if and when that problem comes up again, or some policy. These are things that should have been solved for at the end of the 20th century, and that it's really ridiculous that we're in 2014 and that we haven't solved for. So if you're thinking that this is like an overly technical kind of panel, all that we're essentially talking about is that when you work on a particular atomic artifact of your legal practice, who would benefit by having access to that information? And if you think that it's something that's entirely private, then that's not the type of information that we're talking about. But it's certainly if you've dealt with a particular troll before, if you've dealt with a particular issue in your job or in your business before, and you think that that might be templatizable and that might benefit from a larger community of folks, of smart people looking at it and giving you their advice on what you think you should be doing, that's really what all that we're talking about is sharing information, collaborating on information, and simply leveling the playing field so that we're not favoring folks that have the ability to pay for information and resources that we should all have access to.
Would you please help me thank this fabulous panel?